Hello and welcome to another episode of Anomalies. I'm one of your co-hosts, Dan Hall, and usually on this program, we're talking about things like Bigfoot or UFOs or something that appears to be anomalous. But I had this idea. I hooked up with a couple of my high school buddies here not too long ago, and I thought, there's some pretty anomalous things going on in politics these days. So we're going to devote this show to a discussion, particularly from the legal standpoint, in as much as both of my friends that I'm going to introduce here are were both practicing attorneys, and one of them was a judge. So let's welcome to the show Mike McLaughlin, who
Hello.
was hello. Well, thanks for doing this, Mike. Who grew up in Mountain Home, Idaho, where I grew up, and Mike's dad was an attorney, and then Mike went on to practice law and was also a district court judge in Idaho. So he's got that kind of perspective. And then Charlie Wintersteen, who also was a classmate of mine. And Charlie went on to, where did you go to law school? Charlie,
I'm
I can't
in
remember.
law school here in Chicago at DePaul University.
Yeah, DePaul, right. So that's where Charlie's at now. So it's we're just going to kind of kick around some of the anomalies in the legal field. How's that sound?
Sounds like a winner.
Yeah. Well,
Sounds great.
that's what we're going to do. So whether it's a winner or not, well, and I'll just start with Charlie because I think I kind of know the answer for Mike. Charlie, why did you become an attorney?
Well, it was sort of a kind of the end of a long road. I moved to Chicago in 1979 to go to graduate school at Northwestern University, and my idea then was that I was going to be a professor. I was in a graduate program in philosophy there. And I previously had been quite sure that was what I wanted to do. I wanted to have sort of an academic life and be a professor, and Northwestern just seemed like a great school, and I was all set. I was going to do this. It didn't take me very long to realize I didn't really like it. It seemed like a sort of a weird, maybe Ivy Tower is sort of an overused term, but it seemed kind of cut off from the real world. And at the same time, I was living in Chicago, living the biggest city I'd ever lived in, and it just seemed like there was so much going on. So I stayed in school for 1 year at Northwestern and then quit. And over the next 5 years, I had I guess longer than that. I had a couple different paralegal jobs working for big law firms. One of them was Mayer Brown and Platt, which is now just known as Mayer Brown, and another one was called Tate. They're gone. They've been absorbed by some other firms. And that was sort of interesting work. In both cases, I was involved in this big litigation where they had big teams of lawyers and paralegals working on this big, civil litigation. And it was a good experience in a lot of ways. I learned a lot. But one of the things I learned, well, and at the end of that, I decided, well, look, if I'm going to stay in this business, I might as well go to law school. So I went to law school. I started law school in 1988 when I was 37 years old, and several people said, well, geez, when you graduate, you're going to be 40 years old. And I said, well, in 3 years, I'm going to be 40 years old anyway. I don't want to be 40 years old and still be a paralegal. I'm going to go to law school.
Yeah.
And it was while I was in law school, very quickly in law school, I sort of got on this idea of being an immigration attorney. And, as I said, I really liked being in Chicago. Chicago is a city that has a lot of big immigrant communities, big Polish community, big Mexican community, Lithuanians, Bosnians, people from South America. And I sort of, I liked the idea of representing individuals because I sort of didn't want to do what the people I'd worked for when I was a paralegal did, which is represent big corporations, because they were, in general, I'd say all those people were sort of dissatisfied with the work they were doing. So that was, I graduated in 1991, and by the time I was done with my first year, I was really resolved that I was going to be an immigration lawyer. So worked for a firm for about 8 years during the 90s, doing nothing but immigration, and then in 2001 started my own office. Started out small, but I'm still at it. I have a partner, and we have a couple associates and some support personnel. All I do is immigration, though.
Yeah. Well, there are a lot of issues to be dealt with as far as immigration is concerned. So let's turn to Mike here for a second. I think Mike's path to the law seemed a little bit more straightforward. Mike's dad and my uncle practiced law in this little town in Idaho. And I guess that the fact that your dad was an attorney had a lot to do with why you became an attorney, Mike.
Well, that's, you would think so. I remember going into our counselor, Gerward Peterson, and they would have us do these aptitude tests. And I walked in and he said, Mike, your aptitude and your best set of skills, you ought to consider being a lawyer. And of course, I was 16 at the time, and I didn't want to do what my dad did, because when you're 16 years old,
Right.
you're not going to do anything your dad's doing.
Yeah.
And it was just like an epiphany. And really from that moment on, when you have a counselor tell you that's where your best talents lie, you go with it. And so I was started college. I was in pre-law and then went right into law school. I wish that I had maybe done a little bit more of the path that Charlie took, because I graduated from law school. I was 25. And I wish I would have maybe spent a year or two before going into law school, because that was a long haul. You're going through 4 years of college and then 3 years of law school. But I made it through, and then became a practice with my father, and we had a little bit of differences as far as our business plan. And I wanted to serve the community, so I was elected a prosecuting attorney, and I purchased his law practice and was a sagebrush lawyer in Mountain Home for 15 years. And then fortunately, at age 41, I was appointed as a magistrate judge in Idaho, and which was a great opportunity. You're really you really deal with people at the magistrate level in Idaho's court system. And then fortunately, Governor Batt appointed me as a district judge, moved to Boise, and it was a very rewarding career, and I was blessed. It's very, very fortunate.
I'm kind of like Charlie was referring to academia as kind of ivory towerish. That's the path I chose after some feeble attempts at other things. And although I don't know, I was a adjunct professor in the community college system in Washington. So I don't know how ivory tower that was, but I got to talk to a lot of interesting people, and maybe it affects students in a positive way. So one of the things I remember about my political science class, my intro to political science class, I used a book that essentially said politics, and of course the judicial system is influenced by politics, but it's not politics. Is really composed of three things. Politics is composed of justice, it's composed of equality, and it's composed of power. Those three concepts. So I'd ask you guys to reflect on those three concepts as they affect the judicial system. Mike or Charlie, you want to tackle that?
Well,
Justice, power, and equality.
yeah, you're right about politics. That's why currently federal judges, of course, are appointed for life. I'm going to talk about it from a judicial standpoint. In many state courts, you stand for election every 4 to 6 years, depending on the state. And so again, you have controversial decisions. I had a decision where I invalidated a state tax on trucks that cost the state $26 million. And but you know, you look at the equality side of things, and you look at the justice side of things, and you just have to put the political side of things. You got to put that away. And it's now you're seeing some judges. I know the judge that's handling the documents case involving the former president. She was appointed during the Trump administration, and there's scrutiny on her as to whether or not she's calling the shots, calling balls and strikes, or is she manipulating the strike zone? And so, and you remember that famous statement by the current Chief Justice Roberts. He said, you know, all we do is call balls and strikes. Well, sometimes they decide what the strike zone is. And so it's not, yeah, politics can be there. And hopefully with the judiciary, that doesn't come into play. So I'll let Charlie talk about, you know, how politics affects clearly immigration and the practice of law. It can. So Charlie, you get the next chapter.
Well, I would say the Supreme Court not only calls balls and strikes, but sometimes they get to decide whether that ball over the wall was a homer or a foul.
Yeah, yeah.
He's the Chief Justice was, I don't think, being completely accurate there. Justice, equality, and power. You know, in the world that I operate in, immigration law, justice, completely alien concept. Equality, same thing. Power, yeah, that's what it's about. And I used to, for about 8 or 9 years, I taught an immigration law class at one of the law schools here in Chicago Kent College of Law. And there was a lot of interest in immigration law. And I would go in on the first day and tell the students, you know, all that stuff you've learned about justice and equality and fairness, throw that all out the window. This is a very, very rule-bound system. And you'll be able to get benefits for your clients and help your clients if you understand the rules well, and you can use those rules, and you know, staying within the rules, but knowing the rules and knowing the limits of the rules. It's administrative law. And as I said, justice, I don't think justice has ever been a part of American immigration law. The fact is, there's some Supreme Court decisions that people read when they take immigration law in law school. They go back to the 19th century, called the Chinese Exclusion Act cases. And Congress had passed legislation back in the late 19th century to exclude Chinese people. And the fundamental idea was, we don't like them. They're different from us. They will never ever assimilate because they're just fundamentally different. And there are a number of legal challenges. I think there were a bunch of cases that were consolidated and went up to the Supreme Court multiple times, I think. But the decision of the court was the Constitution gives Congress the right to do with it whatever they want with immigration. And although this may seem contrary to other parts of our law or tradition, if it's what Congress wants, it's the law. And that legislation that was upheld today sounds just awful, horrible, abhorrent. But the reason you read the Chinese Exclusion Act cases is that they've never been overturned. They're still good law. And it's all about what Congress has the power or authority to do. So arguments about equality and justice go nowhere when you're litigating immigration issues.
Charlie, that's an excellent point. I just finished a book, Fever in the Heartland. It's about the Ku Klux Klan in the 1920s. in Indiana, which had a massive number of Ku Klux Klan members, and they passed, as I'm sure you're aware, they passed they lobbied for and were successful in getting legislation that just literally shut the door to immigration into the United States. That was one. They didn't like Catholics, Jews, blacks, or immigrants, and they openly lobbied to prevent immigration other than from certain Northern European countries. And that just, again, emphasizes your point. It was about power. It wasn't about equity or justice. And it's a fascinating book, and I strongly recommend you read it, because it, unfortunately, the Klan lost a lot of membership by the 1930s, but in 1924, 50,000 Klan members marched down Pennsylvania Avenue.
Wow.
Yeah, and so so the immigration issue, you're right. It's and those decisions haven't been overturned. If Congress wants to shut the door on immigration, they can. Now, Charlie, you may want to talk about that. There's the Supreme Court, didn't they come down with a case that pretty much said, hey, states, you don't get to decide what the Department of Homeland Security does in terms of arresting people in the United States. That's a federal decision. The states don't have a say in that. Wasn't there a case in that area?
Yeah, there was a decision in June. I think it was U.S. versus Texas. There were two states, Texas and Louisiana, and this came out of during the first year of the Biden administration. There was some kind of executive order. I think it was an executive order. It wasn't regulations, but policy memorandum or executive order about immigration enforcement. And the general idea was, there are 11 million undocumented people in the United States. And there's tremendous demand for the resources of the Immigration and Customs Enforcement, ICE, which is the enforcement arm of the Department of Homeland Security. And we're going to prioritize our resources and try to use them in cases where the people who we'll focus on the people who should be deported first, meaning people with serious criminal convictions, or people who are in some way a threat to the community. And somebody who's undocumented and working a job somewhere and raising a family, but other than that is not violating the law. Those are going to be a low priority. And there were suits by these two states, Texas and Louisiana, and there may have been others as well. And their argument was, this is a burden on us. This policy encourages illegal immigration, and that ends up being a burden on the states. And the decision of the court in that case that came out in June was that the states didn't have standing. Is that this agency, Department of Homeland Security, they had the authority to sort of set their own enforcement priorities, and the states really couldn't demonstrate that they'd been harmed. They didn't like it because those are states where people, the voting public has a lower opinion of immigration, and they want more restriction. And just because they don't like it, well, too bad. They don't have to like it. The Department of Homeland Security has the authority to set their enforcement priorities however they want to do it. But this has just gone on, boy. Suits by state governments. The cases that have reached the Supreme Court that relate to immigration during the last 10 years or so a lot of them have to do with state objections to federal immigration policies, and they have to do with the authority of the president and the agency to create new programs on their own.
Right. because Congress hasn't acted.
Right. This sort of worked out in the Obama administration the following way. When Obama was elected, he thought, well, one of the things I'm going to do is reform our immigration system. It's not functioning. It doesn't work for anybody. It doesn't work for businesses, doesn't work for communities, doesn't work for agriculture, doesn't work for healthcare, doesn't work for anybody. I'm going to fix this. And he thought that the path to getting congressional support would be, he would be tough on enforcement. He would demonstrate to Congress, in particular Republican members of Congress, that he could be tough on immigration, and that after he did that, they would be willing to work with him on some reforms. Well, he was plenty tough on the enforcement, but he got no cooperation from the Republicans. They didn't want any part of it. So finally in 2012, right in the summer before the election, he instituted this program, Deferred Action for Childhood Arrivals, DACA. And the legislation, one of the pieces of legislation he wanted to pass was called the DREAM Act. The idea with the DREAM Act is there's all these people who were brought here when they were young. They didn't have any choice of being brought here, so you can't say that they did anything wrong. They've grown up here, they've been educated, they're ready to work, a lot of them are working. We should just take this group of people, and the first thing we do is grant them some kind of status so they can have a life here. So he created this program without any legislation, just administratively, sort of justifying it in terms of setting enforcement priorities. These people are a low enforcement priority, and therefore we're going to give them work authorization and protection against deportation. And there were states who filed lawsuits to block that. I think Texas was the top of the list, but there were plenty of others. And then there was they picked Texas to file the lawsuit because they thought they would get a favorable reception in Texas in particular, and in the Fifth Circuit in general. And there was a decision that the DACA, Obama tried to expand the program at some point after it had been there for a year or two. And there was a decision from a Texas court that was upheld by the Fifth Circuit Court of Appeals, U.S. Court of Appeals in Texas, upholding that decision that said that it was outside the bounds of Obama's authority, of the Department of Homeland Security's authority. And that decision, the government, the Obama Department of Homeland Security, appealed to the Supreme Court. And at that point, I think that was 2016, when there were only 8 members. So there were four for holding the Texas decision and for overturning the Fifth Circuit decision. So it just stood.
And that's low-hanging fruit. I mean, to me, it just makes sense. Congress could, that's a group of individuals that clearly should be allowed to stay and have citizenship. You pointed it out. They've grown up here. They have no connection to their parents' native homeland. They're productive, and every day they have wonderment. Where am I going to be? And hopefully Congress will act on it. Dan, getting to your question about precedent.
Yeah, that's where I was going to go next.
Yeah, precedent. I mean, you can see the uncertainty when Congress doesn't act, and when the courts reverse long-standing precedent cases that held certain rulings, whether it's affirmative action, whether it's the abortion issue. Again, this court really takes a rather light view of the importance of precedent. And the problem that happens, I'll just talk about a controversial subject, and that's abortion. When hospitals and professionals moved to a state. They set up the necessary medical teams, the equipment to provide that kind of a service, whether it's a medical necessity or whether it's abortion on demand, whatever the case may be. And now that state, because it's no longer a constitutional right guaranteed by the United States Constitution, the state, like our home state of Idaho, just out and out has abolished abortion. Doctors are leaving hospital units that normally provided some of those services, particularly for some of these complex and troubled pregnancies. They've left the state because they can't provide the services. Well, that again, they relied on a precedent, Roe versus Wade, that was in place for decades. And again, with affirmative action, though even the original decision making about affirmative action in higher education, they said it should have an end date at some point in time. You had committees, you had folks working on trying to bring minorities properly into universities and colleges so that they were proportionally represented. That's all gone now. And in fact, it's going to be interesting with the freshman classes coming into a lot of these universities this year. Are they going to have to completely reevaluate how they went about deciding who gets to go to be enrolled in the college or university? So precedent is very, very important. I realize that, you know, you look at Plessy v. Ferguson, which said separate but equal, which was just a horrible decision after Brown, and of course Brown versus Board of Education changed all that. But you just have to be very, very careful because people rely upon those rulings, and when you completely reverse them, it causes tremendous disruption, as you're seeing now with some of the horrific stories about women who have complications where really an abortion would be in the interest of the mother surviving, and now professionals can't perform those kind of operations in many of these states. It's really created chaos, and so that's my take on the importance of precedent.
Well, it's funny that you were saying that, because as you were talking about precedents, I thought about Plessy versus Ferguson and the Dred Scott decision. So if you go back far enough, you see where precedents allowed the creation of a system that really wasn't fair to anybody. But you've got to kind of leap beyond that. Maybe that's one of the roles of the court, is to reflect changing social mores.
Sure.
So it's interesting that you mentioned that. So Charlie, you want to weigh in on precedents there?
Yeah, and I guess I would sort of want to echo what Mike said about settled expectations and stability. It's funny, the Republican Party used to be the party of, you know, stability and sort of moving slowly with changes, and that court that when they had a big majority that was appointed by Republican presidents, has just sort of tipped everything over, with especially with abortion. Now, I do a lot of work, a lot of immigration work with healthcare systems and healthcare providers. OBGYN residency programs are really in turmoil right now, especially in these states that have severe restrictions on abortion, because I mean, there's a general acknowledgement that in some cases, to protect the life of the mother, it's necessary. Well, to have people that do that, it has to be part of your training when you're doing the residency. But if people are concerned about being sued, keeping their license, whether they're going to have insurance coverage, if they if they do these procedures or teach people how to do these procedures, you have there's a big hole in the training of all these OBGYN residents in states with restrictive laws on abortion. And they're trying to put together solutions like, well, maybe we could send, our residents to do some rotations in a hospital outside the state. But it's not real clear that that is going to be acceptable to these if individuals have the ability to sue over this abortion issue, to enforce it, there's just so much uncertainty that nobody wants to put themselves at risk, or their programs at risk. So it's causing a lot of problems in that realm. And it's funny, recently a lot of these states, like I can't remember, Kansas, some others, maybe North Carolina, where their decision by state courts saying, you know what, the right to decide whether or not to have abortion should be a protected right. It is part of our Constitution. You think, well, all these constitutions were more or less based on the U.S. Constitution, and if it's a protected right in the Kansas Constitution, how is it not a protected right in the U.S. Constitution? And it just makes sense. It's just such a personal decision between a patient and the patient's doctor. Why should a state legislature, the government, have the ability to restrict that decision? So it makes sense that it would be a right that would be protected.
Charlie, we go back, Idaho had almost a libertarian view, the Republican Party did many years ago, and you would think that this would be they're putting government right into the middle of people's lives, and that's not the Republican Party that you and I knew from years ago. It's just contrary to what I understood the Republican Party to stand for, but it's a mess. And I saw a recent poll in Ohio where I think there's a ballot or something on the ballot that a significant percentage of the folks in Ohio want to have abortion rights, and so I think it's a detriment to the Republican Party, and we'll see how it plays out in the next election. I think it had an impact in the 2022 election cycle, where the Republicans didn't have some of the gains that they had hoped to have. So we'll see what happens. But you pointed it. I think Illinois is becoming kind of a destination state with all the states around it precluding, or many of the states around it precluding abortions. They're coming to Illinois for that procedure, and certainly that's true in Oregon with Idaho and
Washington too.
Yeah, and Washington State. Yeah, so
in Illinois, there's people coming from Indiana and from Missouri. Missouri has extremely restrictive laws, and Southern Illinois is not that far, from Kentucky, from Memphis, from
right.
a lot of states.
Well, and speaking of precedent, of course, the recent decision in Creative LLC versus Atlantis, where you had the woman in Colorado that was seeking an injunction not to provide a website for a gay couple. Talk about the Supreme Court, I think, opening up a can of worms.
Talk about that one, Mike. That's an interesting one.
So, they stipulated to the facts. Well, one of the facts that they stipulated to, I'll read it to you. She will not produce content that contradicts biblical truth, regardless of who orders it. Well, biblical truth. Christians can't even agree on what the Bible should be.
Right, right.
I mean, you got the same James Bible, you got the Catholic Bible. I mean, the Mormon Church has its own Book of Mormon.
As I well know.
And you have contradictions between the New and the Old Testament. So to me, when they said, well, yeah, they said it was a First Amendment, a free speech issue. And I thought that the dissent was right on, that it was a conduct issue. And but this, now, is somebody going to be able to say, well, I'm not going to do your wedding website because you're of the Jewish faith and you don't believe in the New Testament? I mean, what are they going to say? What are they going to do? Of course, you'd be crazy not to do business with frankly, with transgenders or gay and lesbian folks. I mean, they're customers, but I think they've just created a can of worms. And it was a case that they could have just simply said, we're not going to grant certiorari on. We're just not. It's just not really right for review. But they wanted to speak out. And the one case that they all agreed on, which did make sense, you had a postal worker that didn't want to work on Sundays. That was his faith. That was his Sabbath day. And all of the 9 justices agreed that he could not be compelled to work on Sunday. So there was a couple of decisions that came out where there was some unanimity by the court, but this is one that I think is going to come back to smack them. I really do.
Well, the interesting thing to me about that case in Colorado, as far as I understand it, is there wasn't actually a case or controversy, because that person who didn't want to design a website really didn't have any clients that were asking her to do that.
Right. She
So-
was seeking an injunction. There's a Colorado statute that said that if it prohibits public accommodation from denying full and equal employment of its goods or services to any customer based upon race, creed, disability, sexual orientation, or other statutorily enumerated trait. So you're right. I mean, it was a preemptive kind of thing, but it really wasn't a case or controversy. You're right. You're right on, Dan. That's why I say they shouldn't have taken it, but they
Yeah.
did.
So where else has the Supreme Court gone into the outer limits beside the couple of cases we talked about?
Well, I guess I'd like to back up a little bit and talk about, some decisions that really changed my practice. And those were the decisions on same-sex marriage back in, I think it was 2014 and 2013, 2015. One was the Windsor, U.S. versus Windsor, when the Supreme Court invalidated the Defense of Marriage Act, which said that for any kind of federal programs or federal benefits where marriage is an issue, whether someone's married, marriage can only be between a man and a woman. And then the case a couple of years later where the court determined that the right to marry was so fundamental. It was a fundamental right that could not be denied to same-sex couples. And before that, I remember talking to a lot of same-sex couples back in in 2008, 2009, 2010, where you had a U.S. citizen spouse and a spouse from outside the United States, and they were hoping somehow that they'd be able to, that the U.S. citizen spouse could file an immigrant petition for his or her spouse, so they could get permanent resident status and they could live together in the U.S. And I remember telling people, well, it doesn't do you any good to have me sit here and talk about how unfair this is, but that's the system, and the Immigration Service is not going to lead on this. They're not going to be in the vanguard. they'll do what they're told to do. And I just don't see this happening anytime soon. I mean, you're going to have to figure out another solution. And I was really stunned at how quickly that turned around, because by 2015, 2016, we were doing these immigrant petitions for same-sex couples. A U.S. citizen spouse would file a petition with the Immigration Service for their spouse to immigrate, to get permanent resident status. And what seemed extraordinary in just a few years became very ordinary. And there was a decision where, I mean, I guess that shows you how much the court has changed in the last 8 or 9 years. But these cases like the one about the website, and it sort of makes you wonder whether those gains being somewhat fragile.
Well, your point's well taken. Clarence Thomas made a comment in a dissenting opinion about same-sex marriage, but thank goodness for the full faith and credit clause, because you have about multiple states that allow recognize same-sex marriages, and under the full faith and credit clause, I mean, that train has left the station. If you're married in Massachusetts, a same-sex couple, it has to be recognized in Idaho. And so I think that I would be shocked if the Supreme Court reversed the decision saying that same-sex marriages are constitutionally protected. It's interesting, in Florida, they have now passed a law that, because apparently some of the New England states allow driver's licenses for immigrants, or something along those lines, they will if they're driving in Florida, they can be cited for driving without a driver's license. And it's just smacks of a violation of the full faith and credit clause to the United States Constitution, where in terms of civil laws, which driving is clearly a civil law or privilege, you have to recognize it. And so, the one decision that came down that I did want to talk to your audience about is this decision where legislatures could just, without any judicial review, could decide what legislative districts are, congressional, state legislative districts. They could gerrymander without any review by courts. And fortunately, to me, it was the most dangerous decision before the court, or one of the most. They said no, judges can and should review those to make sure that they're constitutionally permissible. And so they got that one right. But boy, on affirmative action, Charlie, that one, that's really going to set back a lot of folks. And then the other one that really hurt in terms of environmental law is they ruled that the Clean Water Act only applies to rivers, lakes, streams, and reservoirs. It doesn't apply to wetlands. It was an Idaho case where some folks were filling in a wetland to build a home, and they said the EPA came in and said, can't do that, it's a wetland. They had, by administrative law, they'd extended it to wetlands. And the Supreme Court said, nope, it's not wetlands. Congress didn't intend that. And anybody that understands fundamental Clean Water Act and protecting of waters, wetlands is just vital to that. So, and this Congress is not going to pass or extend it to wetlands. I can just tell you that. So guess what? Developers are going to start going into wetlands and developing them for whatever commercial. And again, that was long-standing administrative law for many, many years, and not now.
So I think we're kind of making the point that the Supreme Court and the current membership of the Supreme Court needs to change. There needs to be a fix. I guess the question is how you fix it. And there are a variety of different options out there that here discussed, from expanding the court, the number on the court, to term limits on the court. What would your guys' response be to that those kind of fixes?
Mine would be that, and again, it would require a constitutional amendment, but you would have 30 years of service as a federal district judge, court of appeals judge, or Supreme Court justice. I think that's plenty of years of good service. I think financially for the men and women that leave the practice of law, many times it's a lucrative practice, and they take a financial reduction in their earnings to do it. 30 years is a good career. I think you're at the top of your game, and whether you start at age 40 or 50, and then you're done. I think that would be my. I don't think we need to stack more judges on the court. I think 9's plenty. That's just my opinion.
Why wouldn't that be a good fix? Because if you look at historically, the court has had more than 9 judges.
Well, I think, my favorite story is if you took all the lawyers and judges and placed them end to end around the globe, they'd never reach a conclusion. So I think whether you have 9 or 11 or 15, well, Dan, I actually was not aware that there had been more than 9. You've taught me a lesson here. So, Franklin Roosevelt wanted to increase the size of the court because many of his programs were being ruled as unconstitutional by the court, and so that was tried, and of course didn't get any. There was a criticism of him; it didn't go through. But I just think you've got 9 very bright minds, and you're going to get correct decisions. But that's just my thoughts on it. I think if you limit the amount of time they're on the court when they're in their prime years, that I think that's a solution that I would back. But Charlie, what do you think?
Well, I think that makes sense too. I mean, what you want are some reforms that are not partisan, that make the court function better. And term limits, I think that makes sense. And you could point to a lot of people who have been on the court who probably were on there too long, who just didn't want to give up. Then you have the situation where people are holding on, trying to make it to the next election. Poor Ruth Bader Ginsburg, she probably would have been happy to have a little peace and quiet for a couple of years instead of trying to hang on until Trump lost the election. And the other thing is, if there's a Republican administration and there's a Supreme Court justice who's coming up on 30 years, somebody that we think is really great, all of a sudden we're not going to be happy about this 30-year rule. That's going to happen. And I don't know, it seems like it needs to be less partisan.
And how do you do that, though?
The whole country has to be less partisan for the Supreme Court nomination and confirmation process to be less partisan. We're wishing for the moon.
Yeah.
Well, and what I'm thinking about is those people, and I couldn't tell you who specifically. I guess it was probably Neil Gorsuch and at least 1 or 2 others who, when they went before Congress and were asked about precedents as far as Roe versus Wade, they identified the importance of that, and then they turn around and vote against it. So you can say one thing in a congressional confirmation hearing and then act differently later on.
Yeah, and I would say that I have been. I'm trying to be positive here. I've been the last 10 years with John Roberts. The way he's tried to, kind of hold back the bomb throwers on the court
Yeah.
and work to create some consensus, uphold precedent. The job he did in putting together a majority to uphold the Affordable Care Act in
Yeah. Yeah.
2011 or whenever that was really was masterful.
Yeah.
Republican appointed um, Chief Justice, and going back, what's his name? Was appointed by Nixon. Justice Stevens, who was our hero for years, was appointed by a Republican president. But
Yeah, remember Earl Warren was appointed by Dwight Eisenhower, and they tried to impeach him.
Right.
And I think the biggest challenge right now for the court are ethics.
Mhm.
The Senate, of course, is trying to pass some ethics for the Supreme Court, and it's not going to make it out of the Senate, and definitely would. And so, but what's going on both sides? I mean, there's of course Clarence Thomas, there's Alito, there's but even I think it was Justice Sotomayor on a book thing. I think Charlie, I hope that Chief Justice Roberts says, "Hey, we got to sit down. We're losing our credibility as a court." I've read many comments by federal district judges, courts of appeals judges that wouldn't accept a pen from a litigant after they'd made a favorable decision. And for these justices to be going on these luxury vacations with these wealthy members of a political party, it's just they're blind to the appearance of impropriety that brings up, that comes into play.
And why has the Supreme Court been exempted from the code of ethics like many other judicial bodies have to abide by?
Well, that's a good question. It's a separate branch. They're
to maintain their independence.
And so they can. I mean, there's always this a fight over whether or not the legislative branch can impose certain kinds of rules. The courts have said, no, we make our rules, you don't. And so that applies to ethics as well. Now, of course, again, the courts of appeal around the United States, all the district judges and federal magistrate judges have a code of judicial conduct. And of course, all the state courts do. And so it's very hypocritical. Why don't you just throw in an extra line that it applies to the justices of the United States Supreme Court? I don't get it either, Dan, but that's why it's a separate branch, and the legislature and the executive do not have the authority to compel it.
But it relates to the authority of the court. I mean, these recent decisions where they threw out years and years of precedent, apparently on a very partisan basis, undermines the authority of the court. And if at the same time you have these ethics issues erupting from the same people who voted in favor of those decisions,
Yeah.
I think, and I'm sure that's Chief Justice Roberts' concern, preserving the authority of the court. I mean, boy, the court, as we've been talking about, is called on to decide some important issues. 2000, they had to decide who was going to become president of the United States.
Right.
There's no confidence in the court. If the whole thing seems sleazy and corrupt, that's just, it's destabilizing.
Yeah, it is the confidence, and polls show that the confidence that people have in the objectivity and fairness, the equality, those very terms that we talked about at the beginning of this podcast, they don't believe that the courts are as unbiased and not influenced by politics. The whole credibility of the court has really gone down in light of, as Charlie pointed out, certainly some of the changes in precedent, but these ethics issues, they're serious, in my opinion.
And
Kind of
that,
a, go ahead. Go ahead. Charlie.
that sort of emphasizes the point we were making earlier about the appointment of Merrick Garland, that he was selected by Obama with the idea that, look, the Congress is really divided, is very close. Here's a guy who will be acceptable to just about everybody. He'd been recently confirmed for a seat on the DC Circuit Court. Had a lot of support and had a lot of credibility and had a reputation of somebody who was not partisan, who would be fair. And you think, boy, do we need that guy on the Supreme Court right now?
Yeah, yeah.
So the thing is as this 6-member Republican conservative contingent comes up with more and more decisions where they're overturning precedent, and they seem like bomb throwers, like the bomb throwers are in charge. Then the other 3 justices, I think they're getting more harsh in their dissents.
Yeah.
And you wonder sometimes, how they all get along in the same rooms, where they all sit there together and in conference and debate these cases. How did that happen?
Yeah, wasn't it ironic that Ruth Bader Ginsburg and Anton Scalia were just best of friends? And
That is ironic.
They were just on the opposite. And we need more of that. I mean, you can't make it personal. And unfortunately, you see a lot of politics getting personal. And yeah, Dan, it's these are unsettled times. But if you go back and read what was going on during, particularly when Teddy Roosevelt and the Bull Moose Party, and of course Taft was running for president, and of course Woodrow Wilson. Oh my goodness! I mean, the media was one way or the other. Kind of like what you have with Fox versus maybe MSNBC. I mean, newspapers again, not really focusing on facts, but focusing on opinions. We've had difficult times like this in our past. And of course, we saw it even when we were growing up during the Vietnam War, and a lot of the unrest then. So it happens. Hopefully we'll steer the other way, and things will be more. The whole point is that, in my opinion, many people can tell you more about their pro quarterback statistics than they can talk to you about what their congressman has voted on.
Yeah.
And Benjamin Franklin said it when he came out of the Constitutional Convention in Philadelphia. A woman asked what kind of government we have, and he said, well, we have a democratic republic if we can keep it.
Yeah, if you can keep it.
If we can
profound.
keep it. And we've got to, instead of just somebody voting, well, this person's got a D or an R after their name, you need to start finding out, what do they stand for?
Right.
And so I'll get off that soapbox, but.
Well, that's a good soapbox to be on, because I would be on it too. As a former educator, critical thinking skills and learning critical thinking skills to kind of tackle misinformation is something that's pretty much lacking in our society. I want to kind of end on one note here, and this parallels something I'm working on in a totally different venue, but I think it's the same kind of idea. What would you say to the average citizen, and maybe Mike is kind of saying this through the educational piece, what would you say that the average citizen can do to improve the judicial atmosphere in the United States? Would you have any suggestions for the average citizen as to how to go about doing that?
Well, of course, the great thing that we have in this country is the jury system. So obviously report for jury duty. And again, it's a great insulator against, frankly, against the government. I mean, those jurors decide the question of innocence or guilt and or civil cases. And so, and I think write your congressman and say, let's consider perhaps a constitutional amendment on the issue of lifetime appointments. Get active that way, and press again Congress to at least consider passing an ethics bill. I mean, it's a question whether or not the courts have to accept it. But I just think just being more aware of what's going on and understanding what goes on in the judicial system, and judges do it all the time, and lawyers the same. They reach out to educate people on the process so that they do have a little more confidence in our justice system and the concept of justice and equality.
Charlie, what would you say?
Well, I guess I would want people to sort of try to get outside their own perspective a little bit, and question some of the stuff that they've always accepted as true. I mean, and on both sides. I mean, I've generally had a sort of a democratic progressive outlook, but a lot of the people we've elected, I'm sort of disappointed in them. I'll give you an example on this immigration issue. There's a woman elected from Congress here in Chicago recently. Somebody that I knew briefly, and she's very concerned about immigration. And she said when she was and she was elected from a district that has a lot of immigrants, and so immigration reform is important to her. So she announced when she arrived in Washington that was going to be her big priority, is immigration reform. And I get these fundraising emails from her, and she listed her accomplishments during the first 100 days. And she says, well, I stood up to the Republicans on this, and I called the Republicans on this, and I called them out on something else. Those were what she listed as her accomplishments. And I thought, and this is a smart woman, a well-intentioned woman, but she's sort of fallen into this path that's going to lead nowhere for immigration reform. I would say the first thing she needs to do is go talk to some Republican congressmen, talk to the people from Oklahoma, and say, what are the communities, the businessmen, the farmers in your district, what are they concerned about? Because there's things that need to be changed in the immigration system. Like, bring in more doctors, more people to work in agriculture, and I was disappointed in the fact that talking to Republicans seems to be very low on the priorities. The emphasis seems to be on standing up to Republicans and calling out. And there's there's plenty of I mean, they're in the news every day, these people who are Republican representatives who think their job is to go on and on about Hunter Biden and you think, well, you Republican members, you must have some ideas about governance and the budget other than Hunter Biden. Why don't you go talk to these Democratic members about how maybe you could work together?
Novel concept.
Part of the
working
problem is,
together.
at least in the House of Representatives, well, it's true really of the US Senate, they're spending a tremendous amount of their time fundraising. I mean, they're in Washington, DC. They fly in typically on Monday night. They're there Tuesday through Thursday, and then they're back at their home state. And you read about the friendships between Democrats, Republicans, and independents when they lived in Washington, DC, at least spent time there and got to know each other personally. And that's missing. And I hope that, that can be changed by both Chuck Schumer and by certainly Kevin McCarthy. And just, let's stick around Washington a little more and not just be going back home to fundraise and do the things that really don't create camaraderie of the kind that will help get legislation through. It's always been about compromise. And it just, your congressman that you pointed out, she's not making friends with Republicans, and you're educated enough to know that that's just not working. But apparently with some others, it works.
The other part of it is, if I'm sitting here proposing that she take a more open attitude and listen to the other side, it wouldn't take too long after she started doing that when she would be attacked. Because there's a lot of her constituents who would be all over her case about hanging out with Republicans, and that's not what we sent you there for. So it's kind of on us too, the voters.
Yeah.
I mean,
Well,
one
go
more
ahead.
on that. The woman in Southern Washington, it was Jamie Herrera Butler's district. The woman who got elected there, who runs a auto repair shop.
Right. I can't remember her name. She's a Democrat.
She has voted. Yeah, she won that election, which surprised everybody. And she has voted with Republicans a few times, and she's been attacked pretty viciously over it. So we can't sit around all day and kind of point our fingers at Fox News and say, "Oh, those are horrible people."
Well, we could, but I don't know if that would do any good.
Well,
Go ahead.
I just want to segue into your world a little bit, Dan. Can you believe what's happening with this Webb telescope? Is that the most phenomenal thing that we've...
There are a lot of phenomenal things out there, and I live sometimes in a world that most people have no idea exists, and maybe that's good because it might scare the hell out of them. One of the things I want to say in closing here is that I really appreciate you guys. I appreciate the fact that we're still friends after all these years. You guys were first off the bench. Mike, you might have even been a starter on that sophomore basketball team. I only came in when there was no... Yeah, he was. Yeah, I only got to play when the game was so far out of reach that I couldn't do any damage. But I really appreciate the fact that we're still connected and that you guys wanted to come on the show today. That meant a lot to me.
Well, thank you, Dan and Charlie, and you guys are buds, and we survived Mountain Home.
Yeah, we did. Well, you guys stay in touch, okay?
All right. Thank you for this opportunity, Dan.
Yeah, we'll do it again.
All right.
We'll do it again.
All right.
Have a good night.
All right.
Okay.
Bye.
Thanks, Mike. Thanks, Dan. See you soon.